Welcome, everyone. We're just going to give it a couple minutes to get going here. Thank you for joining us here today. We're just going to give it a couple minutes for folks to log in. Welcome, folks. It's noontime, but we're going to give it a couple more minutes for folks to log in. Just going to give it another minute or so for folks to log in, and then we'll get going. All right, it is 2 minutes after the hour. Thank you for joining us today on your Wednesday lunchtime. Thank you for attending this session titled Recreational Marijuana Implications for Planning and Zoning in New York State. This is part of the 2021 Joint Planning Conference hosted by the New York Upstate Chapter of the American Planning Association in partnership with the New York Planning Federation. My name is Mark Castiglione. I have the privilege of serving as the president of the New York Upstate Chapter of the American Planning Association. I'm so happy that you're able to join us here today. Before we get started, I need to cover a little bit of housekeeping. Thank you first to our conference's premier sponsor, Hodgson & Russ, and the sponsor for this session, MJ Engineering. Without our sponsors, this conference would not be possible. We want to let you know that all of our sessions are going to be recorded and available online through the conference Eventbrite page. As videos become available, they're going to be posted. We're going to be doing the question and answer in the Q&A box. So if you have a question, please type it in there and we will get to it as we can. Mainly, we'll be holding questions till the end of the session today. AICP planners can claim CM credits by watching the video recording of this session if they're not able to watch it live. Planning and zoning board members may be able to receive training credits by watching the videos, but that depends on what your local municipality allows in that regard. All attendees are automatically muted, and we will address questions, like I said, at the end of today's session. I will be pasting in the CM credit number for the certified planners in the chat box. And all registrants will receive an email about 24 hours after this session begins as certifying that they did attend this session. That email can be presented to your planning and zoning board or town board to claim credit for the training session today. Our session today will provide an overview of the provisions of the Marijuana Regulation and Taxation Act, with particular focus on the impacts to planning and zoning decision-making. The session will also highlight the discretion communities have in implementing the law, provide an overview to the regulatory landscape, and explore lessons learned from other states that have initiated recreational marijuana. We'll also take a look at what potential license holders for retail and commercial operations will be looking for when they are looking to cite facilities. It is now my pleasure to introduce our panelists today. I am going to introduce all the panelists and introduce our first speaker. So we are particularly pleased to welcome Tremaine Wright here. She is the chair of the newly formed New York State Cannabis Control Board. We're pleased that she's able to join us here today. And I'll hold on her bio for her introduction, but I wanted to introduce our other speakers first. We also have Wade Beltramo. Wade is the general counsel for the New York State Conference of Mayors. He oversees NYCOM's legal department and amicus curiae program. He also handles general legal inquiries, including the areas of economic development, emergency management, First Amendment, government operations, housing, property, maintenance, streets and sidewalks. Anything that you want an answer to, Wade is your man at NYCOM. Apparently he has 6 or 7 presentations today alone, so he's a very busy guy training municipalities all over the state. Thank you for joining us, Wade. Jeff Bagg, he's a city planner for East Hampton, Massachusetts. He's been there since February 2018. Planners in municipalities play a critical role at the intersection of transportation, land use, and in small cities, they also play a large role in economic development. Jeff has a great history in providing technical assistance related to the rollout of recreational marijuana in Massachusetts, having previously worked for a regional planning commission in Massachusetts. Jeff is considered an expert in the field of recreational marijuana and land use in Massachusetts. We're so happy he's able to join us today. Our last panelist is F.L. Gorman. Francis Leo Gorman is a commercial real estate attorney and partner with the law firm of Harris Beach. He represents a lot of organizations and companies on the national, regional, and local level, focusing on zoning and land use, particularly commercial leasing, acquisitions, development of real estate, and related litigation. He's a member of Harris Beach's cannabis industry team, the New York State Bar Association's Committee on Cannabis Law, as well as the retail committee of New York State Cannabis Growers and Processors Association. And he'll be providing some perspective on the panel of what the cannabis businesses and industry is really looking for when they're looking to cite businesses in communities across the state. So without any further ado, it's my distinct pleasure to introduce our first speaker again, Chairman Tremaine Wright from the Cannabis Control Board. She is a former member or veteran of the New York State Assembly, and she served as the first director of the Department of Financial Services Statewide Office of Financial Inclusion and Empowerment. She is an attorney, entrepreneur, small business owner, and activist who is a second-generation Bedford Stuyvesant resident invested in preserving the rich legacy of her community and building a strong foundation for the future. She has dedicated her career to empowering and creating opportunities for her neighbors and her community, and she has been empowered by the New York State Senate in her role as chair of the Cannabis Control Board, and is leading the rollout of this very ambitious timeline and program for New York State. So without any further ado, I'll stop sharing my screen and turn it over to Chair Wright.
Good morning, everyone, or good afternoon, rather. I am really pleased to be here with everyone and excited to engage on this conversation with you. As I know, everyone is thinking about what's going to happen in New York State. How are we going to roll this out? What have we learned in the process? And where are we moving? So I'm happy to engage New Yorkers generally as we are moving forward with this. Of course, we have had an opportunity to do some work in the state already. We've had medical and hemp growing for the past at least 5 years. So we are making changes, expanding, and looking forward to recreation. So today I'm really pleased to share with you a brief overview of the MRTA, some of the components of our equity and economic justice program. I will very briefly discuss what's going on with our record expungement, an update on where we are, some of the expansion that has happened in under the MRTA already in our medical and hemp growing programs, what's next, and what we can look forward to, and how we need all of New Yorkers to be involved in this process. So the MRTA, our Marijuana Regulation and Taxation Act, it's our framework for production and sale of cannabis. We are currently engaged in creating a new adult use cannabis program. However, we are also expanding medical cannabis as well as our cannabinoid hemp program. This is our shift towards a public health framework. We are committed to the principles of public safety, economic justice, social justice, and some restorative justice measures so that we can address those who have been harmed by the war on drugs. I think important for this group to consider and to be aware of is that we have created 9 individual license types under the MRTA. The cultivators, which I think we are all very familiar with, these are going to be our growers, cloning, harvesting, drying, trimming, the nurseries. They're going to do clones, immature plants and seeds, process. And I want to just bring attention there. We've already gotten a number of florists who want to know and understand how they participate and where do they fit into this plan as we're beginning to grow. Processors, that's the extracts, concentrates, compounds, manufacturing, but it also, and not listed here, but it includes the packaging. So I think we will have a robust packaging and or branding ideas that are going to be coming out of New York State. Our distributors, obviously wholesale, the dispensary, direct to our on-site consumption spaces, as well as to our delivery services. Retailers, which I think is probably getting the most conversation in the state. Everyone wants to be a retailer at this moment, but I think that as we begin to discuss and help people understand all of the opportunity that exists under the MRTA, that we will see some people waning away from retail models, and they will begin to explore other things that are available to them. We have created a delivery of cannabis to consumers. There's the on-site consumption, which will be likened probably to our bars. Adult use cooperatives, I think we'll see that in some of the spaces. It does not allow for sales directly to consumers. So we will see that in the spaces where people want to own sort of the vertical that we're moving away from, but it will give them the opportunity to grow a business democratically owned and operated by its members. And then we have the micro business, which will be likened to our craft beer, small winery businesses that many of you are familiar with. Under the MRTA, we are required to implement a social and economic equity plan. We wanted to prioritize those who have been harmed by the prohibition on cannabis. We want to make sure that 50% of all adult use licenses are distributed to social and economic justice equity applicants. That includes those who come from targeted communities, MWBEs, distressed farmers, as well as service-disabled veteran-owned businesses. So we will be prioritizing their participation in the recreational space, and we will make sure that they receive 50% of all adult use licenses. And remember, there are 9 types. Additionally, we are automatically expunging individuals' past marijuana convictions, and we are mandated that 40% of adult use cannabis tax revenue be reinvested into communities that had previously been harmed by the prohibition and our war on drugs. So as you can tell, we have a strong equity component to the bill. We will be working on incubator programs. We will be citing them throughout the state. We have a 2-tiered market structure that prohibits vertical integration. So the vertical integration is largely what you see that operates in our medical cannabis space, where people control from seed to sale. We are trying to move away from that model. Thus, the reason we have 9 different license types. And we want to make sure that we get people involved in all spaces and all opportunities. We are mindful that in other states, that licenses that had been distributed to social and economic equity applicants had been transferred to other participants. We understand and know that we will prohibit the transfer within 3 years unless it is to another qualified social equity applicant. As I mentioned, the 9 adult use license types, and we will be giving priority to those who have been harmed. The MRTA does not only legalize, we are expunging your records for anyone that had been previously convicted of actions and activities that are no longer criminalized. That includes criminal possession, unlawful sale, or the smoking of cannabis. So those are already being automatically expunged. We've already expunged almost 200,000. We have sealed almost 200,000 under our 2019 expungement legislation. And currently, we are in the process of suppressing, sealing, and/or expunging over 200,000 marijuana-related charges in New York State. We had only about 45 people who were actually in custody. 34 remain, but that's because the charge, although we have expunged the related marijuana charges, they are currently incarcerated due to some other offenses that are not related to marijuana. If you are concerned or working with any of our local partners to help people understand where they stand under the law, if their records have been sealed, if they've already been expunged, we want to direct them to our newyorkcourts.gov site, which is listed here on the page. Because while this is happening automatically, oftentimes people want to know what's the status, how are they impacted, what does it mean if it's expunged versus sealed. So we want them to go to the courts. They are actively engaged. So are docs and DCJS, they are all working so that people can understand where they are in the process. What does it mean moving forward? Whether or not they should be looking for the expungement immediately if the sealing gets them to the space that they need. The Office of Cannabis Management has just gotten up and running. We were officially established on October 5th at our first board meeting. At that time, we hired our Chief Equity Officer along with 21 other senior staff members. And so we want to say thank you to Governor Hochul as well as the legislature for working quickly to appoint and also to empower us so that we can move forward. We know that New York State has been waiting, and we know that New York State is ready to begin the process of rolling out what recreational cannabis looks like in this state. We have already prepared an 18-month calendar for ourselves. It is an aggressive calendar. There are lots of touch points there, but that's what we're hoping for, 18 months to be able to launch the adult use program. We're already working on the regulations, figuring out what we need to include. We're trying to expand and improve the existing cannabis programs in the state. But as I said, 18 months is our goal, and we're moving in that direction. During the first board meeting, we expanded the medical cannabis program. We approved the sale of whole flower. The medical home cultivation regulations have been released for the 60-day public comment period. The list of certifying practitioners to actually prescribe any cannabis substance has been increased. Anybody that can prescribe has the ability to prescribe marijuana, or I should say cannabis products. We have increased supply that can be dispensed from 30 days to 60-day supplies, so patients do not have to go back every month. We've waived the registration fee for patients as well as caregivers, and we're currently streamlining the approval process for spaces that want to be designated as caregiver sites. That includes hospitals and schools. Of importance to this group in particular, we know that cities, towns, and villages have the opportunity to opt out under the MRTA. They may not opt out of adult use legalization. We want to be really clear with people about that. What you have the ability to control are whether or not you will allow dispensaries, retail dispensaries, or on-site consumption licenses within their jurisdiction. And that determination must be made by December 31st of this year. You may opt out. However, it may be overruled by a voter referendum. And we do know that a number of our localities are actually using that mechanism, and that is their strategy and plan. To opt out, then it's put it before the people as a referendum. It is okay if they do that. You may opt in at any point by referendum. However, you may only opt out by December 31st. This is the only mechanism that they have to prohibit the operation of adult use dispensaries and on-site consumption sites in their space. However, I want to remind everyone, our localities have the ability and the authority to pass laws and regulations that govern time, place, and manner of adult use licenses. I'm sorry, I skipped too far ahead. I wanted to bring you back to one thing. Here, one of the things that I wanted to bring to everyone's attention in thinking about how dispensaries and consumption licenses will be rolled out and how they will interact with our local governments and our municipalities is that we will require under licensing that any applicant notify the municipality where they plan to operate no less than 30 days and no more than 270 days before filing their application. The board will ultimately produce a standardized form to facilitate this process. Similar to what we are familiar with under SLA regulations, the MRTA will require that dispensaries be no fewer than 500 feet from schools and 200 feet from houses of worship. And additionally, we know that the municipalities are concerned with the tax distribution that will come from the 4% local excise tax. And we know that 25% will go to the county and the 75% will be distributed to cities, towns, and villages. I'd say those are probably the high points. We're very familiar with the notification point and the distances, but we will be working with locals to execute a very robust public health and safety program. Everything from driving, we will address everything from driving under the influence, use while pregnant, protecting youth, secure storage in our homes. And also we want to make sure that when we discuss the medical use that we lead the charge in explaining to people what the medicinal uses are and how we might be expanding those uses so that it's really a safe, regulated market. And that's what we will be promoting and supporting out of our policy department. We invite you all to please sign up at cannabis.ny.gov so that you can get updates. You fill out the form, just like it says up here on the screen, and you'll be able to get information from us periodically that fits your needs and purposes. Thank you.
Well, thanks so much, Chairperson Wright, for that insightful overview of the law and its provisions. We hope you can stay with us for the duration of the presentation, but if you have other obligations, we certainly understand. So without any further ado, we're going to transfer the presentation over to Wade Beltramo. I see the planners out there already have a lot of spicy questions in the Q&A box. Thanks, Wade, for fielding some of those already. And hopefully he'll be able to answer some of them in his remarks right now. So without any further ado, Wade.
Yeah, hopefully everybody should be able to see my screen right now, correct? And my presentation, or no, did I not do that? I should be going, sure.
You're good.
All right, excellent. Good afternoon, everybody. My name is Wade Beltramo. As Mark mentioned, I won't go back over my my background, just to say that I work for the New York State Conference of Mayors, which is a not-for-profit association that represents the state, city, and village governments. We provide training, publications. I handle questions and emails every day, a lot these days on cannabis, but also on all other issues. We do have sister associations, an association of towns that represents town governments, and then counties that represents county governments, and they do basically the same thing we do. Not as well. I'm joking. I'm kidding my colleagues over there, but they do the same thing. So this is obviously a hot topic. I did try to answer some of the questions in the Q&A dialogue box, but we're up and running now. I'm going to go pretty quickly here because this topic could be a multi-day conference. We've got an hour here. So one of the things I want to reiterate, which Chair Wright already hit on, is that there are 9 different types of licensees, and the type of licensee that you're dealing with will impact the type of regulation that can be imposed by a local government. And I'm going to go over that hopefully in a little bit more detail. I want to stress this as well. Right now, did I advance the slide? Why am I not seeing my own slide here? Did the slide advance?
It did not advance. You're still on the same screen.
I'm still on the screen. Why am I on the same screen? What is going on? Here we go. There we go. I had the Q&A dialogue box up over it. Sorry. So it's important to understand what these licensed types of operations are, and hopefully that'll be fleshed out as I go forward. I do want to stress it's legal right now in the state of New York for individuals to use and possess cannabis. There are limitations. It's not 100% free for all, but any individual can possess up to 3 ounces of cannabis and up to 24 grams of concentrated cannabis. They can consume it. They can possess it. They have to be at least 21 years or older. Sales right now are not allowed. I gotta stress that as well. There's some entrepreneurs out there who are trying to be creative and give away cannabis. That is not allowed currently. The only way to sell cannabis in the state of New York is to be licensed by the Cannabis Control Board and the Office of Cannabis Management, and they haven't issued any licenses. So anybody who's selling cannabis is doing it illegally, and they could be prosecuted. I just want to put that out there. So real quick, from the local government's perspective, the types of regulations really fall into these 4 different categories. And right now, the hot topic is opting out because there is a deadline, December 31st of this year, for local governments to opt out. But local governments do need to be thinking about these other types of regulations. And the land use regulations fall into 2 categories generally. Regulations of retail dispensaries and on-site consumption establishments, but then also regulations of all the other different types of licensees. And when I've done presentations on cannabis, and I've been doing quite a few, I generally start out with my presentation by saying the theme of the presentation is to be determined, because the Cannabis Control Board got a late start, not because of their own fault. They just didn't get appointed by the powers that be in the state until relatively recently. And so they are working diligently, but until we get regulations from the CCB and OCM, we're not going to have a ton of answers that a lot of people have questions for. Like, we really want to see what the full fleshed out regulatory scheme looks like before local governments move forward, right? And I know that's an issue of concern for many local legislative bodies. The final area of regulation does deal with public consumption. While individuals can possess and consume cannabis, the MRTA amended many different laws. It created a new cannabis law, it amended the penal law, it amended the tax law, it amended the labor law, and it also amended the New York State Public Health Law to include cannabis in the Clean Air Act that regulated the public smoking of tobacco. And I'm going to talk a little bit about each of these in greater detail, hopefully fairly quickly. It was already discussed, but again, this is the huge topic right now, the local opt-out. Opt-out is left to cities, villages, and towns. It only applies to retail dispensaries and or on-site consumption establishments. And somebody asked, hey, can it be and or? It can be and or. A local government can opt out of retail dispensaries or on-site consumption establishments, or both. It's up to them. If a local government does nothing, then a retail establishment, a dispensary, or an on-site consumption establishment could locate within that municipality, so long as they're complying with local land use regulations and they receive a license from the state. That's in a nutshell, right? The specifics are very important, obviously. So this opt-out provision, and Mark, I think, alluded to this as well, it doesn't apply to the other 7 types of licensees. You can't opt out of allowing a processor or a cultivator or a distributor to locate within your municipality. So just to be clear on that. The local law opting out is subject to a permissive referendum. Somebody asked in the Q&A dialogue box, what's the procedure for that? When NYCOM has a publication, if you're a member of a city or village, you can definitely get it from our website. Our website has access to that publication for free to our members. It's different for villages than it is for cities and towns. I'm not going to go into that. That's its own 3-hour presentation, how to conduct a referenda. The referendum does not need to be conducted by the end of the year. The local law must be adopted by the end of the year. And a lot of communities are taking the approach that because this is kind of a one-way street, you either have to opt out on or before December 31st. If you don't do that, then you lose your opportunity to opt out. If you opt out, you may at some later date repeal that opt-out provision and allow a retail dispensary and or on-site consumption establishment to locate within your municipality. You can do that at any time. There is no way, and somebody asked this in the Q&A dialogue box as well, if the community, if a village board of trustees or city council or town council doesn't adopt a local law opting out, can the citizens or residents of the municipality petition to have them opt out? They can do that, but it doesn't have any legal significance. It's a political document. It wouldn't trigger a referendum or trigger the opt-out. That's not how it's not a proposition in that respect. I will note too, because many communities have previously opted out of retail sales prior to when the law was enacted in this year, those opt-outs have no force and effect. If you have an opt-out that you enacted back in 2019, when the governor first put cannabis legalization in his executive budget, which we had many communities do, those local laws really don't have any force in effect. Another thing to note, I'm moving on from opt-out, going very quickly here this afternoon. State preemption, the cannabis law section 131 specifically preempts county, cities, towns, and villages from adopting any regulation pertaining to the operation or licensure of registered organizations. And what does this mean? Jeff's going to talk a little bit about what they do in Massachusetts. I have to put this out there. I think it's great. I think people should, if you're interested in this, you should take a trip over to Massachusetts to see how things look in those communities. I think you can learn a lot. But one of the things to note is that in Massachusetts, they have the ability to have community host agreements, an agreement between the local government and the licensed operators. We do not have that in the state of New York. We are operating simply on regulations. There's no CHAs in the state of New York. With this preemption language in place, I think there may be some clarification that hopefully we'll get from the CCB, and if not from them, then maybe from court rulings down the road about what this preemption specifically means. It's our interpretation at the Conference of Mayors that local governments, that these licensed entities are not totally exempt from local regulations. For example, you couldn't have a processor or distributor locate within a residential community in violation of local residential zoning laws, right? That's clearly not the intent of the legislature to allow that type of operations. But you do need to tread lightly with the understanding that the state has enacted a massive regulated market in place, and that is their goal and objective. So with that, let's take a look a little bit from our perspective at zoning and what it looks like depending on the license type. I'm really noting, and the reason I note this is because there's a difference between the language in the statute for dispensaries and on-site consumption establishments and all of the other types of licensed entities. Specifically, Cannabis Law Section 131 allows cities, villages, and towns to regulate the time, place, and manner of adult use. And I say adult use because there's medical cannabis, which has its own separate regulations that are different than adult use. Obviously, they're ongoing. There's hemp regulations. We're really focused on adult use here today, that allows local governments to regulate the time, place, and manner of adult use cannabis retail dispensaries and or on-site consumption establishments, so long as those regulations do not make the operation unreasonably impracticable as determined by the Cannabis Control Board. And there's a lot going on there. One of the things I will note is that time, place, and manner is really interesting language to have in what we would generally term land use regulations. From an attorney's perspective, that is traditional First Amendment jurisprudence. It's not zoning language. So what does that mean? We shall see. Again, our recommendation here is that local government should be, approaching this from traditional kind of land use regulations. The other thing, well, I'll hold off and make sure I get to this in a second. So very quickly. So that's with respect to retail dispensaries and on-site consumption establishments. For all of the other types of adult use licensees, they're still subject to the traditional zoning of a local government. Now, again, this is not expressly addressed or clarified in the MRTA in the cannabis law language, but in our opinion, that you could still have special use permits or site plan approval or architectural approvals for these types of entities. One of the things I will note, however, and this is what I'm advising all of our members, is that you shouldn't be treating entity. I did two slides very quickly. You shouldn't be treating a cannabis business is any different than another business. And by that, I mean a processor is a processor, a distributor is a distributor, a nursery is a nursery. If you shouldn't single out, in my opinion, at least not at this point, until we get some perhaps additional clarification, a nursery for cannabis different than you would have a nursery for flowers or other types of agricultural products. Same thing for processing. From a government perspective, I don't know what the rationale would be for treating cannabis businesses differently. That's the first point. The second point is the state has evidenced the fact that they want to allow cannabis in the state of New York. And so they've created this regulated scheme to legalize and authorize cannabis within the state of New York. So I just want to stress that. Any zoning regulations that are being drafted or looked at, you should treat cannabis no different than any other types of similar businesses. And with that, I will also note, again, here, this is kind of my Venn diagram of the different types of regulations. Again, it is perhaps maybe they'll all be treated the same somewhere down the road, but we do have specific language that is specific for dispensaries and on-site consumption establishments. One of the things I'll point out with respect to dispensaries and on-site consumption establishments, and Chairperson Wright alluded to this as well, there is part of the model of the cannabis regulations are modeled after our alcohol regulations in the state of New York. It's not 100%, don't get me wrong. It's not like they copied and pasted everything, but that there is that general kind of some of the things they took from the ABC law. Not everything. She mentioned vertical integration, so we're taking a different path there in some of this stuff. But one of the things I'm advising all my members with respect to local land use regulations, if you allow a bar in your community, you should treat on-site consumption establishments probably similarly, unless you can just justify a different regulation, right? If you allow liquor stores in one part of your municipality, you should really think long and hard about not allowing dispensaries in that same location or zoning district. Again, I think it's the onus or burden really is going to be on the local government to justify treating a dispensary different than a liquor store, treating an on-site consumption establishment different than a bar or some other restaurant where alcohol is sold, for example. The chair already talked about notification, so I just put that out there. Finally, a couple more slides, last slides. The public consumption, again, I mentioned this. This is going to be an area of hot topic. Currently, the Public Health Law Article 13 prohibits smoking and vaping of both tobacco and cannabis in all of these locations. The law itself specifically states that local governments are not preempted from imposing additional, more stringent or restrictive standards than are set forth in 13A. So it's the opinion of the Conference of Mayors that cities, villages, towns can adopt regulations preventing smoking or vaping on municipally owned property clearly, and in other areas such as public sidewalks. One caveat there too, we do recommend if you're going to prohibit smoking of cannabis, you do the same thing with respect to tobacco. You don't treat cannabis and tobacco really differently in that context. Again, partly because the state itself has evidenced the fact that it wants to treat smoking of tobacco and cannabis similarly by putting this in that regulation. So again, I forwarded my slide deck to Mark, and so he can feel free to share that. Here's again, just kind of a general overview of those regulations. And I went a little bit longer. If you have any questions, I'll try to answer them in the Q&A dialog box. So.
Thanks, Wade. That was an impressive synopsis of all the ins and outs of a lot of these different topics. I will mention that we'll likely go over time here, but I don't think it's going to be a problem. This is a topic of interest. So I just wanted to remove the pressure from our upcoming speakers to know that there is some flexibility to go beyond 1 p.m. today. So with that, I'll turn it over to Jeff Bagg to talk about some lessons learned and considerations that they encountered in Massachusetts during the recreational marijuana rollout.
Great. Thank you, everybody, for having me here. I'm really humbled and grateful and appreciative that you invited me here. I'm going to try, I have a lot of images, and I'm going to try to kind of cut to the chase for you all. But I did, with a little bit of extra time, I am hoping to give you just a snapshot of East Hampton. And I think it's important because we're not that far away. And I will say that I totally acknowledge that many components of the Massachusetts law are different than the New York State law. And so I'm cognizant of that. But I will come at this from a sort of a land use perspective. And I was really involved in the rollout in Massachusetts. I was able to participate in panels with members of the Cannabis Control Commission here, and fairly recently did a panel on delivery with the chair of the state's Cannabis Control Commission too. So I've been kind of involved as much as possible, and now I'm in a particular location working for the city of East Hampton. Kind of quick, it's very similar. A lot of this stuff rings very true and similar to what you guys are all experiencing. But we had medical marijuana for a little while in Massachusetts, and then in 2018, what started out as recreational turned into, the name was formally changed to adult use in 2018. We did try in East Hampton to do some equity revisions, but something I'll try to touch on a little bit later, we were not able to pull that off. It was structured differently in Massachusetts, where the industry was initiated and then the equity components were built in later, and it created a couple different kind of unique struggles. 2020, we were making some potential amendments to cultivation, and then we just passed some delivery regulations. Again, same thing with the equity. The delivery was not originally included in Massachusetts law, and it came later, and so we did adopt some provisions for delivery. We adopted our ordinance in March of 2018, and that's important, I guess, as a reference point, because the Massachusetts Control Commission finished their regulations in December. So they finished them in December. Actually, I might be off a year. This might be March. No, I'm correct. So the December before this is when they finished. So we had 4 months with the final regulations to craft our final zoning. We allow 6 retail operations in the city, and that's a kind of a discussion piece that you will likely encounter. We had a limit of, we could not limit it to less than 20% of the alcohol establishments. So, that was, our number was up to like 9 or 10, and we ended up at 6 through a lot of discussion. Our setback, we had some flexibility, and we chose 350 feet from a school, 200 feet from another dispensary. We set up a couple provisions to mirror what Massachusetts process was at the state level. And what we felt like was a safeguard for us was to require an applicant, a local applicant to our planning board, to have gotten to a certain stage with the Cannabis Control Commission to show that they were, really committed to a site, had some of their ducks in a row. And so we wanted to have them a little bit more organized. And I don't know the structure of the New York State law, but that was important for us because we did find that there were a lot of entities kind of speculating and kind of traveling around to different municipalities. And we really want to make sure that, a very small planning department and staff time was only going to be spent on people who are kind of serious about locating in East Hampton. This is a map. It's updated as of July 2021 from the Cannabis Control Commission here. It's got sort of the number of all licenses. This isn't really broken out in any specific way, but I will say that in Massachusetts, the Control Commission has put out a lot of information, and it has been very helpful and very transparent. And that's a really important tool for municipalities to be kind of gathering that information at the state level too. The star here represents where East Hampton is. We're kind of in the I-91 corridor, which runs north and south. And then we're kind of in this position where the Mass Pike runs east and west. So we're right in that vicinity of the number 54 there in Hampshire County. This slide, collaboration, in terms of East Hampton's specific situation, there was a lot of political support to be embracing cannabis as a new industry. So this is just a representative image of the mayor, Mayor LaChapelle, is standing in the middle. There's 2 city councilors, myself, the chief of police, and the owner operator of the first dispensary in East Hampton, and we're here at like the ribbon cutting. So, this is probably a little bit unique, but I do want to touch on the idea that this opt-out conversation that you guys are all having, if you can understand your political will, if you have political leaders who want to be supportive of the industry, you would likely be able to advance and be at the front. And I would say that East Hampton was at the leading edge of the industry, and it has helped to be there. It has been challenging at the same time. So I think your opt-out, discussions are pretty interesting. And I have some slides I'm going to go to in a minute that kind of elaborate on some of those lessons that we learned. We have 7 host community agreements, which I understand is not really a thing in New York, but we have 5 adult use dispensaries operating, 2 cultivation facilities, 1 delivery, 1 hemp cultivator. And what I threw up here for some information was revenues from INSA that was the first dispensary that we've opened here. So in 2 years, it was really the first 2 years, from the 3% excise tax. So it sounds like what I learned from your slide is, there's a 4% kind of excise tax, and the municipalities would get 75% of that. In 2 years, that netted us $700,000. So, if you're thinking in terms of whether or not this will be beneficial, especially those communities at the leading edge, that amount is not small. In Massachusetts, we were lucky. It's a blessing and a curse. The host community agreements and the impact fees, we also generated double that. So we have that additional income, and we're projected to receive another $800,000 from the 3% excise in this coming year. So we've seen real numbers attached to this in terms of East Hampton's rollout. I'm going to skip around here now because in the interest of time, I'm going to skip through. I was going to kind of give you a preview and an overview of East Hampton, but I'm going to skip that. What I did want to note was, let me get to the correct slide. I will
encourage everyone to visit East Hampton. It's a lovely community. You should connect with it at your discretion.
Yes, thank you for the plug. We're a former mill town. We are in the middle of an arts and culture kind of revitalization, but it's really been in the works for 20 years. But I will give this kind of thumbnail sketch of the operations that we do have. This is INSA. This is the first one that opened in East Hampton. The first floor is retail. The upper 3 floors of this mill is cultivation. So they are at 100,000 square feet of cultivation space. I think the chairperson mentioned the vertical integration. INSA started that way, and it's quite literally vertically integrated in this one operation. But in some communities, actually, I'll talk to that in a second. This is a dispensary on our highway business corridor. We have one that's kind of situated in our downtown. And so this was pretty unique when we were going through the permitting process and discussing this. This is our first one that's kind of just in a walking setting, and you park across the street in a municipal parking lot. And there were a lot of concerns and questions about how this would function. But I would say that all the demand has gone down. And so the issues about 100 people waiting in line outside this door. Just we're never there, and that's a good thing. This is a site that was a former building supply store and storage, and they opened the dispensary, and the space on the back they renovated, and they are in the process currently to add the beverage manufacturing outfit in that space there. And so even in our short period of time, the industry itself has evolved, and so there's a lot of cannabis cultivation and processing, and then here we are, kind of the evolution is now they're going to do infused seltzers in this facility, and that's kind of in the short 3 or 4 years we've been here, that'll be happening soon. This is an abandoned auto dealership that was purchased and is being converted to retail. This is a space that kind of laid vacant for a little while, a couple years, and it's close to the highway. And this was kind of the first delivery operation. So in Massachusetts, it was a wholesale kind of situation. So they would bring cannabis materials there, they might repackage them, and then they would have a fleet of cars that leave here. And so they are saying that they may be one of the first delivery operators to be licensed in Massachusetts, and they were talking really keenly about being first to the market, and the delivery numbers are tight, and so they really wanted to be first. And so we bent over backwards to kind of make a process for them, and they did the community input and they did their public hearings, but they were able to get the special permit that they needed. So this is not my style to put a bunch of words on here, but for accessibility later, I did this. But I have a few minutes here and then I'll be done. But the state rollout was a huge lift at the state level, but it was also a huge lift for municipalities, and it was challenging to follow. So things like one of my notes here, I didn't have it on the slide, was that the rapid rollout, often several times required the municipalities to be taking steps before there was actually published guidance from the state. And so you really have to kind of think about, identifying a person in your community who can kind of be following all of this information. And I did carve off, I think, for land use, it's certain considerations that you want to be really looking at that I think are different than health and law enforcement, because I think there's a whole bucket of conversations that those professionals will have, and they do interact with land use, but they are kind of different. They deal with different things. I respect what Mark is doing with the regional aspect, and my quick anecdote was that for East Hampton, that was at the leading edge of this. We were making decisions without guidance. We had to be really making key decisions. We were doing that without models or a lot of specific information. So that was harder for the leading edge communities, but I think for communities that delayed, I think those materials became available and it kind of became a little bit easier. I think when you're talking about zoning and regulations, time, place, and manner, it'll be very difficult to cover everything. I think the tendency will be to cover everything, make it kind of complicated, and the alternative is to set up base regulations and be prepared to tweak them as more information becomes available, especially if you want to accept the industry in the early stages. One observation is that there is a real potential for real estate to get held by cannabis companies. And so, it's a real thing that you will see if you're not already seeing it. It will happen. And, I think it could be a blessing and a curse for communities depending. I'm recommending that you, as any municipal employee who's going to be working on this, track your time and consider it unique. I did have a note that, these operators are going to be coming in with needs. They're going to be seeking, your opinions on, your community's opinions on where to go. And I think it's pretty unique. Even though you are going to be trying to treat them like other businesses, they are well capitalized. They come with legal expertise behind them. And they have a lot of experience from other states. And the final thing is that they're under pressure to get to market. So I think those things are unique. So there are some ways to distinguish a cannabis industry from some other aspects. Since you don't have the host community agreement, maybe considering fees and application fees to help cover some of the costs, because I think as a community who wants to support this, you are going to have a lot of extra work, but that extra work will pay off, because if you can bring a company in and get them established early, that will actually result in more revenue coming to your community. I would recommend local permitting kind of really try to supplement the state review process. So some, really try not to duplicate some of the heavy lifting that the Bureau of Cannabis Control Board is going to be doing, vetting of people, vetting of financials, vetting of their legal history or their criminal history or query checks. I would just recommend that you defer, as much as you feel comfortable, but there's going to be people doing that, and it's not necessarily time well spent at the local level. I know I'm running long. I really apologize. I think land use related, one of the things that we did thoughtfully, but it actually really paid off in terms of East Hampton, was we required cannabis establishments to use existing buildings. And we believe that it's time, place, and manner. And it fits, we had that same language come from our statute as well. It may not be applicable depending on where you are in New York State, but if your community has empty storefronts or empty buildings, this was really useful. East Hampton had conversions of all kinds of existing buildings. And I would say that anecdotally, the community next to us is Holyoke. And they had no limits on any establishments. They really opened up their community to the cannabis industry, and they are seeing, these old mills that have lied vacant for 20, 30 years become occupied by cannabis cultivation and manufacturing. And I think I have somewhere else a note that cannabis is I would consider it mostly an industrial activity. We don't have a lot of outdoor cultivation here. The Massachusetts regulations had a lot of restrictions on the testing for mold and other aspects that really kind of hampered outdoor cultivation. But indoor is really a really important thing for people to think about. It's jobs. The facility that we have in East Hampton with 100,000 square feet of cultivation space has 90 employees. And so they are pretty much, they're not our largest employer, but they are significant. And where the former mill, had employees, and there's a parking lot across the street that sat vacant for 15 years, it's filled with employee vehicles. And so, the cultivation is really something to be thinking about. I would say that it's generally not as bad as we even thought in Massachusetts in the rollout in terms of traffic. It declines. I would say that the first few operations that get open will see the highest demand. And I think, I would encourage land use boards to try to see that. Try to make sure that your zoning allows for shared parking or parking across the street or parking on a close by site, instead of forcing them to build, excessive amounts of parking that might not be needed. Public perceptions, I believe this is my last slide. The rollout was different in Massachusetts, but at the local level, we did get a lot of debate about legalization, about removing the stigma, and really supporting, people's rights to have access to cannabis. And so that was a really, important part of the debate to understand where East Hampton was. There's a lot of comparisons to alcohol, for good or bad. And then there was a lot of concerns about increased access of cannabis to youth. And so those are all conversations that if you haven't already, you're going to hear about them. Not to be too jokey about it, but you might want to be ready for some heady kind of advertising. We have a couple billboards. I think billboards is a unique thing that, I drive to, we have family in Long Island. And so we drive through Connecticut, and all through Connecticut are billboards for the industry in Massachusetts. And so, there's a lot of things that you'll see depending on your proximity to highways, and access. I think you will see some billboards. It's regulated by the state and it's totally appreciated. But I think, one, play on this is going back to, this is just fun. I just wanted to do this because we have this mountain, Mount Tom. It's one of our, it's the backdrop of East Hampton, and it's the highest peak near East Hampton. And this is a cannabis, reference to the, it's the highest peak near East Hampton, and challenge accepted. And so, they get creative, and that's fine, but I think you should be prepared for the advertising part of this. One of our operators got exclusive rights to a Jerry Garcia brand cannabis, and we were okay with this, but they created this wonderful mural of Jerry Garcia, and that's the industry evolving. And those are the things that you don't quite know at the beginning. You don't know who your operator is going to be, or if they will sign up with some kind of, Justin Bieber brand, cannabis, and it could make or break the operators that you have in your town. So I had a lot more kind of overview of East Hampton stuff, but by and large, we are happy. Some of our residents have complained, another, cannabis dispensary, but we feel pretty comfortable that we've established a limit of 6. We have 5, and we have not had a 6th one come forward yet. And so I think with that, I'll yield and try to go through the Q&A, but I will make the slides available too. So thank you very much for having me.
Thanks so much, Jeff, for that perspective. And, we're hearing that there's not one solid answer. Wade gave his perspective on how communities should approach things, and Jeff gave his perspective. And I am disappointed to mention that I lost the over and under on the Jerry Garcia popping up in the pot panel. I had it at 37 minutes, but it didn't happen until 59 minutes. So there you go. Now it's my pleasure to introduce FL Gorman. And we heard a lot about what the industry partners are looking for. And so FL is going to walk us through some of those considerations today.
Good afternoon. And I wish, Mark, you were closer to the 37 rather than the 59 minutes, but I will try and be very quick, if that's possible for a lawyer. So at our firm, we do represent municipalities. We have a cannabis industry team. I'm working primarily with prospective applicants. And so my presentation is going to be coming at it from that angle. And one of the things that we look at is the members of the Cannabis Control Board. Besides Chairman Wright, and thank you so much for being with us today. But we have a couple legislative picks, Attorney Adam Perry, who's in employment litigation, and former State Senator Jen Metzger, who chaired the Senate Ag Committee. And then we have a couple governor picks, Reuben McDaniels, who's head of DASNY. He was an investment banker for 30 years, and Jessica Garcia, labor organizer. So to me, that means, the state is very key on employment rights, the agricultural industry, and then certainly the financing of it for the social equity applicants. As the prior presenters had talked about, the social and economic equity program is huge as part of this, and it's to prioritize applicants for cannabis licenses or from communities disproportionately impacted by the enforcement of cannabis prohibition, or who qualify as minority or women-owned businesses, distressed farmers, or service-disabled veterans. And I do think that's worth repeating. I think we've all hit on that topic, but that's worth repeating. And then disproportionately impacted by the enforcement of cannabis prohibition. I was wondering when this all began, what did that mean? And there's a quote that's starting to get circulated, but it was from John Ehrlichman. He was White House counsel in the Nixon administration, and his quote is, "The Nixon campaign in 1978 and the Nixon White House after that had two enemies, the anti-war left and black people. You understand what I'm saying? We knew we couldn't make it illegal to be either against war or blacks, but by getting the public to associate the hippies with marijuana and blacks with heroin, and then criminalize both heavily, we could disrupt those communities. We could arrest their leaders, raid their homes, break up their meetings, vilify them night after night on the evening news. Did we know we were lying about the drugs? Of course we did. I mean, that quote is so outrageous, it almost seems to be more fiction than fact, but it is fact. I think, as we represent applicants, we're aware of the intent behind the legislation. I attach a chart here. There's a group, Canasiglieri, who's tracking the opt-in, opt-outs, and of roughly a third of the state's 1,570 municipalities, a third of those are leaning towards opt-out at this point, or more than a third. And if you take a closer look at the slide, and again, this will be available afterwards, but you can get a good sense of where people are going on this. Jeff talked about this a little bit in his presentation about Massachusetts and being first to market. That's like a developer concept or a retail concept all day long, but first to market, I think, is going to be very important here and where we locate these jobs and these facilities. I'm from the Finger Lakes region, and we have the dominant regional mall is in Ontario County, literally just across the border from Monroe County. And this mall ends up generating 25% of the sales tax revenue for Ontario County. And they essentially get most of that money from Monroe County because people are just driving across the state line. And I think you're seeing that with municipalities that are opting out. In some cases, it's going to be the one community that decides to be a leader and accept these entities that they're going to hopefully profit by creating jobs and tax revenue. According to the projections, they're talking about $350 million in yearly tax revenue and the creation of 60,000 jobs. Hopefully that number is low. And they're talking about the projection in the industry being $1.2 billion in sales the first year and $4 billion in 4 or 5 years after that. And certainly in New York City, I think people are looking at that as probably one of the biggest municipal markets in the world. On my slides, I also have what the city of Ithaca estimated in city tax revenue. And then the next slide is just, some of the little economic tidbits that I've come across representing applicants and people and retailers. For example, there's one of the leading grocery-anchored shopping centers in upstate New York. I was talking to one of their leasing agents, and normally they get $20 a square foot for small shop space, and they have a multi-state operator that's offering $45 a square foot. And the grocery operator doesn't quite know what they're going to do. In the Finger Lakes region, some of our prospective operators are expecting up to 300 customers a day, and sales, the average ticket price is $90 per customer. There's a retailer in Massachusetts that has 3 locations. 2 are one's in Newton, one's in Lowell, and we understand they're doing almost $1 million a week in sales. We talked a little bit about signage. My reading of MRTA is the signage is controlled by the Cannabis Control Board, so that's going to be an interesting discussion as the regulations come out. In California, a lot of the acquisitions really depend on how much signage comes with the store. Favored locations for the adult use dispensaries are large parking fields, so some of your underutilized shopping centers or shopping malls, power centers. I think you're going to find, those being very popular with the adult use dispensaries. And then last week they had the MJ BizCon out in Las Vegas. I was fortunate enough to attend that, and one of the participants that I met with was suggesting that 70% of the capital for the cannabis industry is actually coming in from outside the U.S. That may be good, that may be bad, but then I think about Ontario County benefiting from all the Monroe County shoppers and how that is essentially subsidizing the sales tax, the real property taxes for Ontario County. We talked about the opt-in and opt-out. If we skip ahead, the Cannabis Control Board still has a lot of control despite the discussion of local municipalities controlling time, place, and manner restrictions. From a larger perspective, I think what may come down is we're going to have a little push-pull between state preemption and municipal home rule. But the Cannabis Control Board, they look at the number, class, and character of other licenses within the proximity of the proposed license, the effect of the license on pedestrian and vehicular traffic, the existing noise level, and any increased anticipated activity there, the applicant's history of violations, compliance with laws, environmental impacts, and ability to meet energy standards of the facility. So as we represent applicants and as we look at our site selection, we want to make sure that we're going to be fit very nicely into all these categories. In the municipality, while they do have their time, place, and manner restrictions, and later on I'll talk about the notice that has to be given to municipalities, in Section 76.4 of the MRTA, it does talk about you have to give notice to the municipality, and if for some reason the Cannabis Control Board, the municipality has the right actually to submit a letter in opposition or in support of a particular application. If the Cannabis Control Board doesn't follow that recommendation, then they need to provide some reasoning why they didn't follow that application. And some have suggested that that actually could give the Cannabis Control Board some authority to possibly overrule some of the time, place, and manner restrictions that have been enacted by the municipality. Let's see here. We are going to jump up here a little bit to one of the slides, on-site consumption. The on-site consumption licenses, you cannot have an opening or means of entrance or passage for persons or things between the premises and any other room or place in the building. I think that is going to also go more to when you're making your application to the municipality. The municipalities are going to have some ability to enact design requirements, and your applicant is going to need to comply with those design requirements. What we're also starting to see, and if you want to skip ahead to the local law adoption process, is that some municipalities have adopted or are in the process of adopting their local laws to zone for adult use. And so I've outlined, and I'm sure everybody here is very familiar with it, and I'm sure Wade can recite this in his sleep, but the local law adoption process. But we're working with one group where the municipality is not going to opt out. They're in, and they have already, they've adopted out of the on-site consumption, but they have enacted a resolution as to where they're going to allow their adult use dispensaries. So in this case, our particular client has gotten the support from the village, from the town. He's met with the state senator, the state assemblyman, and is trying to make sure all the bases are covered. And this municipality actually, is putting in effect its zoning for the retail cannabis dispensaries. I think there's been a lot of discussion at this point about opt-in and opt-out, but we see a lot of municipalities that have decided that they're going to opt in, that they, are going to start talking and thinking about the actual local law amendments that they're going to pass for the cannabis. In the materials that you have, I also included a zoning amendment for agricultural districts, because cannabis is hemp and they're protected by the ag laws. So if you have outdoor cultivators, we're finding that, they're already covered in the zoning law by whatever agricultural zoning ordinances they have in place. And I have included an example of an agricultural zoning ordinance where there is a current hemp grower. I also have included the zoning ordinance for adult use cannabis establishments from Jeff Bagg's hometown. And that's something to look at. It's very well written. It's got its purpose, scope, definitions. It's got special sections on place, time, and manner, and it's been outlined very well. So Jeff, your municipality did a great job on that. And hopefully you're telling me it's still in place and it hasn't been subject to any lawyers trying to challenge it. So, and then the last one I have in here is a planned development district from the city of Rochester in the Eastman Kodak Business Park. And there is a cultivator in that business park who also has a medical dispensary, and they fit within this planned development district that the city of Rochester put forth. And this one is like 10 pages, it might be 5, 6, 7 pages long, but they do go into design elements. That one's very, very detailed. And so that's also something that, municipalities can look at when they're thinking about, when they've moved past the opt-in, opt-out discussion and they want to start enacting local laws. And then we're going to skip ahead here to zoning and site selection issues for a cannabis retail dispensary. And the award of an adult use retail dispensary license, there's going to be certain conditions. One, the applicant's ability to secure site control of the premises. They have to have site control at least for the length of the license. The length of the license is 2 years. And they have to comply with the time, place, and manner restrictions imposed by the MRTA, which include the local municipal zoning ordinance. And then this also includes the zoning regulations of the city of New York City. And then there's also the obligation to notify the municipality or community board that has jurisdiction over that particular property that intends to apply for a license. They have to provide notice to the municipality at least 30 days, no more than 270 days before the application. And as I said earlier, all licenses are going to expire 2 years after the date of issuance, so you have to have site control at least for those 2 years. The license application, when you're submitting it to the Cannabis Control Board, must specify, among other things, the land, buildings, and facilities that may be used for the license activities, and the description by street and license and number of the licensed premises. The application may be amended, the license may be amended, but you have to go back to CCB for that if you're going to relocate your store. And your license will be void if there's a change in location without prior written approval from CCB. Some of the location restrictions include a retail dispensary must be located in a store with a principal entrance on the street level of a public thoroughfare. No retail dispensary within 500 feet of school grounds or 200 feet from a house of worship, and I'm sure that's been referenced before. Advertising, you can't advertise within 500 feet of school, daycare, playgrounds, and we'll be looking to the CCB to come out with regulations on signage. Signage, as we know, is very important to retailers. And then I know this is the upstate APA, but there is an interactive map of New York City, which locates nearby schools with specific addresses. We talked about time, place, and manner restrictions. Wade covered that in his presentation. He also talked about unreasonably impracticable, basically saying, yeah, we're going to allow it, but we're going to put you in a bad place or bad time, so you actually can't operate whatsoever, and those obviously would be subject to challenge. One of the discussions that we see with citing is, most CBD stores are out, they're around. Some are in very nice locations, they're beautiful stores, and the question is going to be whether or not they allow adult use facilities to be well located, or they decide to put the stores in industrial areas that are hard to get to. And that could certainly chill the ability of the store to successfully market its product and maybe force people back, into the black market, because one of the goals of the legislation is also try to bring these legacy marketers in compliance with state law. We talked about notice to the municipality, or if you're in New York City, you got to give notice to the community board. And that's my presentation in a nutshell. I think it's going to be great for the economy of New York State. I think it's going to be very nice for the social equity applicants, and I look forward to New York State being a leader in adult use throughout the country and being a model for the rest of the states. And thank you, Chairman Wright, for your future service and your present service.
Well, thanks, FL, for that rapid fire overview. Like Wade said in the beginning, this could be a whole weekend conference on this topic.
Yes.
So we jammed in a lot of really good information. All of the slides that the presenters provided today will be posted on the conference webpage, in addition to a recording of this session. So hopefully folks will find that useful. We have our panel. This is a record for any panel during this conference. Our panelists have answered 37 questions in the Q&A, and we'll also post the Q&A conversation on the conference webpage as well. There's still a few questions out there, and I'm happy to report that this session will be increased from 1 hour of CM credits to 1.5 hours. So that leaves us with 9 minutes for questions. So we can start with some of the questions that have yet to be answered in the Q&A box. And I'll just start with one from Jill Hank, and she asks if there have been any programs in Massachusetts to benchmark the energy consumption of cultivating facilities, or incentives for them to use renewables. We know that these facilities use a lot of water, they use a lot of energy. Has there been any thought about those topics in Massachusetts?
I definitely think there has, and I thought I tried to answer that one. In East Hampton, we didn't have the staff capacity to ask for it and understand it and track it. So we did not assess that, but I do know at the state level, the state regulations that are, that would be a precursor. If you had extra time, you could look at the Massachusetts state regulations for a lot of this stuff and see what Massachusetts did. But there are requirements for these, especially cultivators, to submit their projected energy use and have an energy efficiency plan. So what we did in a lot of cases, we deferred to the state. We deferred to their review of a lot of these proposals. But yeah, as you have a little bit more time, that could be something to consider, or try to incentivize, your establishments to do that, or provide the information up front.
I'll just jump in, and I hopped on that, Jeff. You did answer that question, and I added to it. I mean, it's definitely a concern for our membership, and not only water, but you mentioned electric usage, and we have many municipalities that have municipal electric utilities, and because their rates are substantially lower than the larger utilities, of course, they're going to be a prime location to locate cultivators, right, for indoor grow operations. So obviously the technology is getting better and more efficient. And so it's not as energy intensive as it used to be, but it's still pretty energy intensive. So that is definitely a concern for communities that have, for municipal water systems and sewer systems and municipal electric. It's something those communities should be taking into consideration regarding site plan review and things of that nature on those. And it's a valid, appropriate governmental interest when formulating your local land use regulations. It is a potential issue to differentiate treating cannabis cultivators differently than other types of operations. So just if you're going to treat cannabis businesses differently, I'm recommending strongly the local government be able to identify a reason or rationale for doing so. And there are reasons for treating, businesses differently. And we go to on-site consumption establishments as opposed to, a bar. You can have one drink at a bar and not be over the legal limit for driving. I mean, if you go into an on-site consumption establishment and you take a hit, should you be driving at all? And somebody had a question about enforcement. That's definitely an area of concern. The Chairwoman Wright, there are so many issues that were not addressed that are in the law. So training of local law enforcement officials, providing funding to programs to address substance use and equity. I mean, those are things that none of us actually even talked about today. So if you have an interest, I shared also my summary of the law, which goes into that, and Mark will put that up on the website as well. I take a look at it. There's a lot of questions still to be determined because the regulations, and did we lose Chairperson Wright? They still have to promulgate regulations, right? And that has to be done pursuant to the state's Administrative Procedure Act, which requires the regulations to be drafted and a notice to be put out and have a comment period and then have a finalizing of that where the CCB is going to come back and respond to all the comments that are submitted by all the people who submitted comments. There are going to be thousands of comments submitted. So it's going to be a while. They're going to act with some urgency, but we still have a ways to go before we have operations up and running for sales. So,
Mark, is it okay? It's something that Wade said in that it's a different, but it's the same process that we went through in Massachusetts in that comment period, the promulgation of regulations. That was really important to be following. So everyone will be following that with Wade's help and Mark's help. But an important factor for me to just throw out there, and I don't know that it'll be the same, but it was through that long public comment period is when Massachusetts on-site consumption got taken out. And there was a lot of pushback from public safety officials and public health officials. And a lot of the same questions that you're already raising, like how do you test someone for sobriety after leaving an on-site consumption? So I think there could be pros and cons, and I'm not I'm not saying this is pro, but if you do move forward and that stays in the legislation, New York should be looking to the next town, next community, next state over that actually has passed this, because it's we thought retail was hard. We figured it out, and I think on-site consumption is going to be tricky. It's going to be really challenging and kind of like not like much we've seen before. But I will say in Massachusetts, through that public process, which took many, many months, that's when it got kicked out. And right now, it came back in Massachusetts as a voluntary pilot program. So communities had to opt in to participate in the state's pilot program for on-site consumption. And in my slide, I said status is unknown. I don't know that any municipality has opened an on-site consumption establishment yet. And just to go all the way back, those regulations got published in 2018. So here we are 4 years later, and on-site consumption has not been figured out.
One question related to IDA inducements for large-scale production facilities. I mean, my sense based on what I've heard is that they're all well-funded and they're not going to need IDA inducements. Is that the consensus of this group here?
did we lose FL?
Yes.
I would have deferred to him. I mean, just because they are well funded doesn't mean they're not looking for, more money to make more money. So
Well, I guess the other part of the question is, can they get inducements? Like,
absolutely. I don't think there's, I'd have to go back in the law to double check. I don't believe there's any restrictions on them being, getting an IDA project. There may be some, I'd have to defer. I deal with IDAs, but not in the way of actually implementing or carrying out any projects. I don't know if there's any still reservations because of the challenges at the federal level, but not under state statute. And there's nothing in the MRTA that addresses that or would prohibit or specifically authorize. If they're a distributor, IDAs finance distributors. They finance processing facilities. So to the extent that they do those types of projects, just the simple fact that it's a cannabis, wouldn't give me pause.
all right. We're approaching an hour and a half. I'd just like to thank our speakers. Any closing?
So Eric asked, and I'll note this. How can we best follow the work of the CCB? First of all, I would go to their website. They had their first meeting like almost a month ago. They had their second meeting just last Thursday. They're streaming them live on YouTube, so you can watch those meetings. Regarding the promulgation of rules and regulations, those all have to be noticed and published in the state's what's referred to as the register, and that's at the Department of State website, and that comes out once a week on Wednesday. They just issued the Wednesday one this morning, and they'll promulgate their regulations there. I will note they're already behind on issuing they were supposed to have promulgated regulations for cannabis individuals with medical licenses to home grow by September 30th. Obviously they didn't, and this isn't their fault. This is the fact again that the board didn't get constituted until early September, where most people thought that they would have appointments be made by May or June, and I'll forgo the political wrangling that caused that. So they're behind, but they definitely have an idea, I think, of where they want to go, at least from the staff level. But they've got to come to agreement. It's the 5-member board that gets to vote on these regulations and approving them, and that has to go through that process. So you should hear about it. We at the Conference of Mayors, my colleagues over at the Association of Towns, the counties will be putting out this information. I'm sure Mark, your organization, will also be providing information when it becomes public. And there's a comment period. These regulations are going to be extensive. And so I think people need to focus on it when it happens, but the intent is to move quickly, very quickly, to get these operations up and running. Having said that too, and I noted this in some of the answers, and I don't know if you're going to share those, Mark, that at this point, we're not going to have any legal sales of cannabis, if I had to wager, until 2023. That's really what we're looking at. So there is time for communities to regulate. But you want to be focused on this. You don't want to wait. And the other thing, and to have FL kind of alluded to this, the businesses want to go where they're wanted. Is it possible that you would have a business located in a community where there's a ton of opposition? They may want to go there and fight that fight for a variety of reasons, but they're most likely to go in places where the local officials are working with them and are amenable to their operations. So I just leave that out there. That's a non-legal issue. It's more of a political issue that people need to be aware of. So.
Well, we're at time. I'd just like to thank our speakers, Jeff Bagg, Wade Beltramo, FL Gorman, and of course, Tremaine Wright. As a follow-up, we will be posting all this information on the conference website, including the Q&A back and forth. We're going to be running it back today at 2 p.m., planning ethics, interesting topic. And then again on Friday with some scenario planning to wrap up the conference. Thanks all for your attention, and we look forward to seeing you at 2 p.m.
Thank you very much.